Occasion for me nowadays to introduce at length because the person who introduces usually says only one line that Dr. Chandratri doesn't need any introduction. And therefore when he introduced me at length, it was a pleasure to listen to it. We have been talking about this program for quite some time, and Rajiv has been after me for the last, I think, almost 3 to 4 months. Unfortunately, for one reason or another, it couldn't materialize earlier, and therefore today we have this program in reality. We will discuss in this 4 hours time. We have 2 sessions, one before the tea break, one after the tea break. And during these about 4 hours time, we'll discuss critical aspects of chapters 11, 12 and 13 of the Companies Act 2013. This has been done by me in several programs conducted by CCGRT. I think they have conducted about half a dozen programs on this, and they are also planning a few more. As all of you know, the new Companies Act 2013 consists of 470 sections, 7 schedules, out of which only sections 1 to 205 are relevant for practical purposes for practicing company secretaries as well as employee company secretaries. In other words, at the moment, my recommendation to you all is focus on only sections 1 to 205. Out of these 205 sections also, about 100 sections are not required for day-to-day purposes. And therefore, practically, we are left with about 150 sections. In addition to that, you need good knowledge of only 2 schedules. Actually, for company secretaries, only 1 schedule, that is Schedule 5, which we will discuss in this presentation. Other schedules are not very relevant for day-to-day working. And therefore, the task of relearning is not very difficult really. We have the set of rules which is equivalent to the volume of the Act so far as these 205 sections are concerned. And therefore, there will be some amount of difficulty in learning the rules along with the Act and practicing them, putting them into practice, but that also is not very difficult. Secondly, you will find about 50% of the stuff in this Companies Act in 205 sections is the old one. And there are certain basic principles of company law which can never change. When we talk about directors' duties, when we talk about meetings of directors, quorum, shareholders' meetings, rights of shareholders to attend the meeting, disclosures in the notice of the meeting, voting rights, quorum, I don't think the world over these principles can ever change. What can change is numerical aspects of these provisions. Instead of 5 quorum, there may be 7 quorum. Instead of 5, it may be 10, whatever. Instead of all directors liable to retirement or 2/3 of directors liable to retirement, it would be now all directors except independent directors. But these are only the procedural aspects. I don't think there is much to get unnecessary tension about it. Because everywhere I go, I think this is the 17th or 18th program I am addressing on the New Companies Act, and everywhere I find a kind of uneasiness, anxiety in the minds of company secretaries, because basically it is due to de-learning and relearning. But I don't think you should worry about it at all. And there are not serious problems in the implementation of some of the provisions of this Companies Act, like related party transactions, which we will discuss over here, or key managerial personnel. There are not very serious problems, contrary to what has been highlighted by some people. Yeah, there are some irritants, no doubt about it. There are some drafting problems, and there are some very serious drafting problems which need to be taken care of by the government, earlier the better. And barring those things, I do not think company secretary should get worried about it. On the contrary, I look at it as an opportunity. I definitely look at it as an opportunity. Last 3 months have kept me so much busy that practically every day I spend 4 to 5 hours in drafting 2 or 3 legal opinions. And all that is paying me money, of course. Therefore, for practicing people, this is a grand opportunity, in spite of the kind of agitation that have taken place in Delhi, particularly because of the limit for compulsory appointment of company secretary having been reduced and private companies having been kept out of the purview of this requirement. But I think that also is being taken care of. I am told, and the President has been communicating with the people of our institute. So I think those problems will be definitely sorted out. And with the new government now in place, probably the institute will have to take up the matter with the new minister and press them. So this is what I wanted to talk about as introductory remarks about the New Companies Act and its implementation. Now we go to the main business of this session, this program, and that is my presentation on chapters 11, 12 and 13. I have modified this presentation slightly in order to bring in focus only those critical aspects of these 3 chapters which are very, very relevant for the company secretaries. As Rajiv has rightly pointed out, all these sections 148 to 205 are extremely important for all company secretaries for day-to-day purposes, whether you are in employment or in practice. And therefore, we need to have a very good knowledge of practical aspects of these provisions and also try to find out solutions. Probably during this presentation, you will get answers to many of your problems, many of your queries, and the solutions to your problems. Because as I said, the problems are not as serious as they have been highlighted by some people here and there. So let's start with this presentation, and during my presentation, during my talk, if you feel to ask any question, please do ask, raise your hand, and you are welcome to ask, but it should be only relating to the contents of this presentation and nothing else, because we have a time limit. So we start with section 149 about independent directors. And these companies, every listed company and public companies with paid-up capital of so much, turnover of so much, or aggregate of outstanding loans, debentures, etc. of that amount, will have to have independent directors, at least 1/3. These 3 parameters are alternative to each other. And even if one of them is complied with by you, one of them is satisfied by your company, you will have to comply with these requirements. There is also the concept of minimum number of independent directors, and that is 2. So you must have at least 2 independent directors, but the basic requirement is 1/3 of the total number of directors. And I don't think there is any difficulty about understanding of this. Maybe aggregate of outstanding of loans, debentures, deposits, etc. in the computation of the figures of these three aspects, these three matters will pose some difficulty. But it's quite clear that you should take these amounts according to the previous audited balance sheet. And therefore, I don't think there should be any problem about it. Section 149, subsection 4, points to the kinds of companies which are required to appoint independent directors, and the rules have prescribed the parameters to determine which companies should appoint independent directors. That we have already seen. Every listed company must have it, and even if your company has only debt securities listed on the stock exchange, like debentures, bonds, etc., and you are not otherwise a full-fledged listed company, but only debt securities have been listed, that company will also fall within the category of listed company. Because the definition of listed company has been given in section 2, and according to that definition, every company whose securities are listed on any recognized stock exchange in India will be treated as a listed company. So therefore, such companies also will have to comply with these requirements. Process of appointment. Essentially, the appointment of independent directors is required to be done by the shareholders of the company at a general meeting. But the selection of independent directors is entirely at the discretion of the board. The members have no role to play in that. They have the role to play only in relation to the appointment, approval of appointment. So basically, the independent directors are to be selected and appointed or recommended for appointment to the shareholders by the board. So it is entirely for the board to decide about it. Then there is also a solution provided that if there is a vacancy created by the vacation of office of an independent director for any reason, like resignation, retirement, death, etc., then what should the company do? And that's given in Rule 4 under this chapter. And the board will have to fill that vacancy, but then, as I said, the appointment will require shareholders' approval. Yeah. You can ask now also, but is it possible to provide mic so that it is audible? Because then others can also listen to you.
No, idea is to have more interactive discussion. Sir, in this, if you see the rules, don't you see that there is an inconsistency vis-a-vis the rules and the Schedule 4, which talks about the resignation and removal. It says an independent director who resigns or is removed from the board shall be replaced by a new independent director within a period of not more than 180 days. Where it is talking about 3 months or the next board meeting. So, to my mind, because it's a substantive law, Schedule 4 should be...
Yeah, it should be, the law should be, that should be followed.
Yeah.
The most important aspect of independent directors is that they are not liable to retirement by rotation. In this case, what, I haven't heard the last part. I think what I suggest is, Rajiv, what do you think? We keep the question answer session at the end.
Otherwise the flow
because my flow will be interrupted. And this entire presentation has been made in a flow process manner, taking points one by one, so that others are not affected adversely. So I think let's have question answers at the end. Independent directors are not liable to retirement by rotation. This is a very important aspect of this provision. In other words, apart from independent directors, the company must comply with the requirement of section 152 regarding retirement of directors by rotation. We have to remember sections 255 to 56 of the 1956 Act. The same formula is found in section 152 about the retirement and reappointment, the same procedure, the same numbers, there is no change at all. The only important change is independent directors out of the category of directors liable to retirement by rotation. Sometimes it happens that excluding the independent directors, your company has mainly, out of the remaining directors, mainly executive directors, managing or whole-time directors. And they are not liable to retirement by rotation under the articles of the company. Usually it is provided in the articles that managing and whole-time directors shall not be liable to retirement by rotation till they hold that office. However, in order to comply with these requirements now, requirement of this section as well as 152 subsection 6, there may be occasion in certain companies, and there are occasions in some companies I know very well. For example, in Mumbai there is a listed company which has 10 directors, 8 are independent directors, 2 are executive directors. Both are executive directors, managing and whole time. So if you exclude independent directors from the category of retirable directors, they are left with only 2 executive directors who are not liable to retirement under the articles. However, in such a case also, the company will have to comply with the requirement of section 152 subsection 6 regarding retirement of directors, and therefore you can make the executive directors liable to retirement by rotation, regardless of the fact that your articles provide that they are not liable to retirement. You don't need to alter the articles of association for this purpose, because section 6 of the Companies Act, like section 9 of the Companies Act 1956, gives overriding effect to the provisions of the Act vis-à-vis the articles of the company. For example, in that company in Mumbai, they have proposed a resolution at the next annual general meeting that managing director shall be liable to retirement by rotation, and 1/3 up to 2/3 or all is the requirement. But when you exclude independent directors, out of the remaining, all of them or 2/3 of them should be liable to retirement. Suppose you say that all the non-executive directors who are independent directors are not liable to retirement, and only the executive directors are liable to retirement, and all of them will be liable to retirement. It simply means that out of the 2 directors who are executive directors, 1 will retire at the AGM. So you substantially comply with that requirement of 1/3 of 2/3 to retire at the AGM. And as I said, you don't need to alter the article. But my recommendation is that in the resolution for reappointment of the managing director as a director in that AGM, liable to retirement by rotation and reappointment, you should add 1 sentence. And that sentence should be, the reappointment of the managing director as a director of the company on retirement by rotation shall not constitute a break in his office as the managing director of the company. So that technically there is no break in the term of the office of the managing director. So that takes care of any technical, break arising out of the retirement and reappointment. So that is sufficient. Otherwise, you don't need to take any other care. Tenure, 5 years at a time. And this first appointment will be by ordinary resolution. The second appointment will be by special resolution. Second appointment will also be for 5 years at a time. The law is saying up to 5 years. That means if you wish, you can appoint an independent director for a shorter term than 5 years. It is quite possible. In fact, some companies are thinking on those lines, that they will appoint independent directors initially only for 3 years, and they will reappoint them if they so decide. So that option is also available. One person can be an independent director for maximum 2 terms, 5 years each. That means total 10 years. And thereafter, there will be a cooling off period, an interval of 3 years. And during that interval, that independent director cannot be given any assignment in the company which will give him any pecuniary benefit, like office or place of profit, like a consultant. You cannot engage that person for 3 years as a consultant of the company and pay any remuneration. That's all. Now, this does not mean that you cannot take benefit of the advice of that person in some other way. You don't appoint him to hold any office or place of profit. But for example, if you need inputs of that person, advice of that person, and the board or a committee or the chairman of the company or the managing director invites him to attend a particular meeting and advise the company on a particular issue, that is not barred. You can pay him the sitting fees, the kind of sitting fee which you pay to other directors, and also reimburse the expenses of traveling, etc. But appointment to hold any office or place of profit like a consultancy contract is not permitted. Now, the main question about appointment which is coming up everywhere is, what about the existing independent directors who already hold the office before 1st April 2014, on which date this section became effective? My suggestion is that all the independent directors should be appointed at the next annual general meeting of the company, and the term of 5 years can begin either from the date of the annual general meeting or from 1st April 2014. I don't see any problem in this. And resolutions for their appointment should be included as special business in the notice of the annual general meeting, because this is not an ordinary business, because this is not appointment of a director who is retiring by rotation. This is not a case of reappointment of a director. This is entirely different from the retirement, because they are not liable to retirement. And therefore, this should be included as special business with explanatory statement. I am told that there is some difficulty about form filing. Filing of form in connection with the appointment of independent directors under the new provision of the Companies Act, because the form which is prescribed and the system through which the form is filed will not accept the form of appointment unless there is a form of cessation, like vacation of office. When we file Form 32, when a director retires at the annual general meeting or he ceases to hold the office. And that form you cannot file because technically there is no cessation. So this is a difficulty in relation to the filing of form. On that, my solution is that in the notice of the annual general meeting, in respect of independent directors' appointment, you do not use the word appointment. You just say that these directors the term of these directors is be and is hereby fixed for a period of 5 years pursuant to the provisions of section 149 of the Companies Act 2014, and the term will be 5 years. If this wording is used, it will indicate that there is no fresh appointment. You are not making a fresh appointment as such because they are already appointed. Now you are fixing their term for 5 years and taking them out of the purview of the requirement of directors liable to retirement by rotation. So I think this type of wording, in fact one company in Mumbai, listed company, large listed company, has already issued a notice, including in the notice this type of resolution, so that the resolution will be not for the reappointment as such, but fixing the term of independent directors for a period of 5 years from the date of the annual general meeting. So this is a solution on that problem. Then we go to who can be appointed as independent directors. Now these provisions are applicable to listed as well as unlisted companies. And listed companies are also governed by clause 49 of the listing agreement, which has also been revised now and becoming effective on 1st October 2014. Now there may be a question about this, why there are two sets of regulations, two sets of laws on the same subject, one in the Companies Act, one in the listing agreement. But I think this has been a common feature of our system in India, and unless and until the regulatory authorities and the government authorities come to an understanding that there should be uniform code applicable to particular types of companies, we have no solution. Because unless MCA and SEBI come to an understanding that there should be uniform code for listed companies, and let that code be in the listing agreement only, not in the Companies Act. Why there is a duplication? But, when we argue this, then different types of answers are given by the authorities. When I was talking to one SEBI officer on this subject recently, that why you are making two sets of regulations. Now Companies Act has made a regulation for independent directors. You are also making it. You drop that from the listing agreement. So his answer was, no, we want to make it stricter than the Companies Act. Now, I do not understand why they want to make it stricter than the Companies Act. And if they want this to be done stricter, then they could have suggested to the Ministry of Corporate Affairs that you make it stricter like what we want. But I don't think this problem will be solved ever in this country, so long as these two authorities, try to come to some understanding. Anyway, we are not concerned with that. We company secretaries have to comply and show the management that we are complying with it. Now the problem is about criteria, qualifications, or rather disqualifications. And some people are facing a problem on interpretation of this, but will have to find a way out. For example, the second criteria, the third criteria rather in this is a person who has or had, this is of course grammatically incorrect, but anyway it says who has or had no pecuniary relationship with the company, holding company, subsidiary company, associate company, or their promoters or directors during the two immediately preceding financial years. Pecuniary relationship is not defined. Suppose I pay commission to non-executive directors, or I pay sitting fees. Are they directors having pecuniary relationship or not? Suppose I have a director who is paid fees for professional services, which is now permissible under section 197 without government opinion. It was permissible under the previous act, also under section 309(1) proviso, but government opinion was necessary. Now government opinion is also not necessary. And if I enter into a consultancy contract with a director, paying him some amount by way of consultancy fee in accordance with that statutory provision, does it amount to pecuniary relationship or not? These are the questions which remain unanswered, and that creates problems in the interpretation of this provision because there is no clarity about it. For example, listing agreement clearly says that any remuneration paid to the directors of the company shall not constitute pecuniary relationship. So non-directorial remuneration only or other benefits like consultancy fee, distribution contract, agency contract, commission paid to the director by way of agency, office or place of profit held apart from directorship, all these will be pecuniary relationship. But what about the directorial remuneration? Payment towards expenses incurred by the director for attending board meetings and other assignments of the company. These are the problems which are very peculiar, and there should have been some solution to this in the act itself. Unfortunately, it is not there. The first criteria is that the person should be, in the opinion of the board, a person of integrity and possesses relevant expertise and experience. I do not know how you determine whether a person is a person of integrity or not, and it's very difficult probably in this country to decide that. And also the person who possesses relevant experience and expertise. Now what is relevant experience and expertise? All these words are not defined. Expertise in relation to what? Business of the company or something else? Because if there is something else, then that also might be beneficial to the company, contribution by the director in the company. Experience is also not clear. What is experience? And therefore we have to apply the rules of interpretation in the context of the provision, taking the context of the provision in mind and accordingly interpret. My interpretation is that any remuneration paid to the directors, whether commission, sitting fees, professional services remuneration, will not constitute pecuniary relationship. Expenses reimbursed to the directors also will not constitute pecuniary relationship. Only if, apart from the directorial remuneration and expenses, other than the directorial remuneration and expenses, the company pays the director some amount, either on monthly basis or otherwise, for special services rendered by the director to the company, or derives any pecuniary advantage out of the activities of the company, business of the company, like sale of goods, supply of material, or supply of other services. Suppose the director is running a travel agency and he is rendering services to the company for their business purposes and gets remuneration paid for that service, then it will amount to pecuniary relationship. Likewise, distribution contracts, selling commission, purchasing commission, or profit arising out of transactions of sale and purchase of goods, all these will constitute pecuniary relationship, but not remuneration paid to directors as directors. In the capacity of directors, it will not amount to pecuniary relationship. Then there are several other criteria, and I have broken down all these clauses. There are only 5 clauses, but I have broken down this into item-wise, criteria, and it comes to about 48 criteria. There are 48 criteria which are relevant to decide whether a person is qualified to be appointed as independent director or not. If anybody is interested in having a list of these criteria as broken down by me, please write to me by email. I will provide it to you. I have done it for many purposes like related parties, section 185, independent directors, and certain other things. So I will be happy to supply it to you free of charge. It is the company secretary's duty, and you have to be extremely careful in advising your management whether a person proposed to be appointed would be qualified for the appointment as independent director or not. And we know that we have to be extremely sensitive about it in advising the management. Otherwise, tomorrow if you discover that the person was not disqualified, then the person will have to vacate the office, and you can imagine how embarrassing that will be for you as well as the management of the company. Therefore, I recommend to you, and particularly those who are concerned with listed companies, you will have to keep in front of you both section 149(6) and clause 49 of the listing agreement, and then come to a conclusion whether a person is qualified or not. Otherwise, you will land in trouble, and then, it will be very embarrassing for all of you. Then there is one more requirement in Rule 5, and probably this is in relation to that first criteria which I mentioned. The person possesses relevant expertise and experience. So probably this Rule 5 is in connection with this criteria. And then you can decide, of course, as I said, it is entirely at the discretion of the board to choose a person to be appointed as independent director. And apart from these criteria and listing agreement, there is nothing else which is necessary to be kept in mind regarding the appointment of director. As I said, shareholders have no role to play so far as the selection of the person is concerned. Declaration. You have to take a declaration. This is again a company secretarial duty, which all of you who are concerned should follow. There is no format of this declaration, but I have developed a format for this also. If you are interested, please write to me, I will provide it. Format for declaration under this as well as other provisions of the. There are three kinds of declarations required now from the directors of the company, apart from occasional declarations. One is this, one is under clause 49, and one is the consent to act as a director. So, company secretaries will have to be careful about obtaining from the directors. I have developed a format of the letter to be sent to the director also. You write a letter to the director explaining, the proposed director, explaining what is this and why it is required, and then the format. So, you can definitely make use of that format. Remuneration of independent directors. This is again an important topic, and every management, every board will be interested to know what exactly is the new framework of law regarding remuneration to independent directors. They can be paid sitting fees, which has been now increased up to 1 lakh rupees per meeting for both board as well as committee meetings. So you can pay 1 lakh rupees, up to 1 lakh rupees per meeting as sitting fees, apart from reimbursement of all expenses. However, we shall see when we go to section 197, discussion on 197, remuneration of directors, we shall see there that independent directors now can be paid remuneration on monthly basis, which was not permissible under section 309 without the approval of the central government. If you remember 309 subsection 4 clause B, there was a provision for payment of commission on yearly basis up to 1%, subject to special resolution approval for 5 years. Fine. And then there was another clause below that saying that if you want to pay to your non-executive directors any remuneration on monthly basis, quarterly basis, or fixed amount periodically, then you needed the central government's approval, which has now been dispensed with. And now, independent directors or other non-executive directors also, all non-executive directors can be paid monthly remuneration, subject to 1% limit. We will discuss in detail when we come to section 197. And I am talking about this provision in 197, that is subsection 6. There is some inconsistency between the two, but it is possible to resolve it. Inconsistency can be resolved by giving priority to this provision, 197(6). ESOP cannot be given, shares under ESOP cannot be given to non-executive directors, independent directors. This is again an important provision, not very relevant for day-to-day purposes, but I have heard in many places a kind of uneasiness amongst independent directors because enhancement in the penalties under the new Companies Act. And as you must have noticed, the amount of penalties, fine, punishment by way of fine or imprisonment has been substantially increased in many places. Naturally, therefore, independent directors are asking this question whether we would be liable if your company makes any default or contravention under the Companies Act. Whether we will be liable for that. And obviously, that question has to be answered on the basis of the legal provision. And fortunately, there is a clear-cut provision now taking independent directors out of the purview of officer in default. They are not officers in default as defined in the Companies Act, and therefore they would not be held liable for non-compliances by the company under the Companies Act, except in the circumstances mentioned in this provision. Act of omission or commission has occurred with the knowledge of that director, attributable through board processes, and with his consent or connivance. For example, your company makes a loan to one of the parties which is specified in section 185. We'll come to 185. This is another irritant in the new Companies Act. Suppose you make a loan to one of the parties mentioned in that explanation below 185 section, which section prohibits giving loans to those parties. But you do it. It is a contravention for which there is a penalty. And that loan was approved by the board at a board meeting. It was not given outside the board. It was given with the knowledge of the board. In that situation, unfortunately, independent directors might also be held liable, or guarantee or security. That section talks about guarantees and securities also apart from loans. Only in such circumstances, independent directors would be liable for penal consequences under the Companies Act, but not in other cases like company has not filed annual return. For example, independent directors would not be held liable. It is the officer in default. And in the definition of officer in default, there are two categories of persons. One is executive directors, managing or whole time, CFO, and company secretary. These are the main persons who would be liable. So, in case there is a question from independent directors of your question, of your company, then that question you will have to answer by reference to this provision. Of course, as you know, there is a defense provision in the Companies Act like section 633 of the 1956 Act, if you remember, that directors can be excused from penal consequences if they show that they had acted honestly and reasonably. And the default or non-compliance had taken place without their involvement. So that defense provision is also available. It's there in the new company law also. You have the grace time of 1 year to reconstitute your board in accordance with section 149, particularly in relation to independent directors. In some books there is a mistake. I think some of you might have experienced it. I've seen that in some book, probably in the institute's book also. I mean, this book published by CCH. Yes, it is there in this book also. Subsection 5 ends with subsection 3. And this provision says that within 1 year, the company will have to comply with the requirements of subsection 3. That's not actually subsection 3, that's subsection 4, which talks about independent directors' appointment. There is a printing mistake, but on the website of the MCA, it has been done correctly. It's talking about subsection 4. So please remember that. There is some confusion I have seen in some places. Now, what this means is that within 1 year from 1st April 2014, your company can take necessary steps to reconstitute the board in accordance with the requirements of this section regarding independent directors. Many companies I have seen have already started taking action, and all the annual general meeting notices so far I have seen, all listed companies they have already taken steps to include in the notice of annual general meeting the resolutions for fixing the terms of independent directors for 5 years, as I mentioned earlier. So you can also think on those lines if this provision is applicable to you. So this 1 year period, grace period, obviously gives you the benefit of continuing with the existing structure of the board and then reconstitute it up to 31st March 2015. You can appoint independent directors at an extraordinary general meeting also. You can appoint them now by postal ballot also. Because the new provision on the postal ballot, if you read it carefully, it is a comprehensive provision, wider in scope than the existing provision, and it enables any company to pass any resolution by postal ballot, except the resolutions which are required to be passed to transact ordinary business. Because they are to be done, those businesses are to be transacted only at the annual general meeting. Now that provision has made it possible to pass any resolution by any company in India by postal ballot. So those who wish to take advantage of this postal ballot process instead of calling a meeting can definitely think about it, and company secretaries should advise their managements or their clients accordingly. In fact, some companies have already started the process of passing postal ballot resolutions for different purposes, like increasing the borrowing limit. They have already passed resolution by postal ballot.
Subsection 3 is not that renewal of 1 year. That means now, as regard cooling period is concerned,
We'll come to question answers at the end. Selection of IDs. Government is proposing to create a data bank. I don't know whether the bank will work at all or not, but they have a good plan to create a bank in which you can deposit your CV as a probable candidate for independent directorship, and the companies can choose from this bank. Practicing CS also can do this, so that you could get an opportunity to be appointed as independent director. But this is of course not mandatory. Please remember, this is not mandatory. If you wish, you can go to the bank and try to find out appropriate candidates. Woman director. Every company falling in either of these categories must have one woman director. Of course, my interpretation is that woman director can be either an executive director or a non-executive director, independent director or non-independent director. There is no bar. You have to do this within 6 months. In the case of a new company, casual vacancy, how to fill, etc. These are all procedural matters, and as and when this situation arises, only you will require compliance with this. And that's why I said that out of 205 sections, out of 470, there are hardly 150 sections or so which you really need for your day-to-day purposes as company secretary. And I think it's not difficult to relearn knowledge of 150 sections. There are some teething troubles, but they will be only in the initial period. Small shareholders representative director. This is not mandatory. Please remember, this is not a mandatory requirement, and it's only when you get a requisition from small shareholders of the prescribed number and value, and only if an ordinary resolution for the appointment is passed at the meeting. And on this resolution, non-small shareholders will not be disqualified from voting. I hope I am clear in what I want to say. Non-small shareholders will not be disqualified from voting on this resolution. Yeah. No, actually they have used it may. See, there are problems again about the use of may and shall and or are, but we have to interpret it in the context of the provision. And probably in this provision they have used may, because as you know, the rule of interpretation is that when shall is used, the provision is ordinarily mandatory. When may is used, the provision is ordinarily permissive. But there are several judgments you will find which says that shall should be read as may and may should be read as shall. I have extensively discussed this aspect of interpretation in the publication published in the book published by ICSI. The name of the book is Essential Rules of Statutory Interpretation for Company Secretaries. The book is available here outside the hall and you can buy it. It is basically for company secretaries. I have tried to capsulate not only essential rules of interpretation as used by the courts, but also the meanings of certain expressions like what is the meaning of notwithstanding anything contained, save as otherwise provided, without prejudice to, nothing in this section shall apply, provided that, so on and so forth. It's a jungle of expressions used in legal drafting, but without that you cannot survive. I always say nowadays that no company secretary can in future survive successfully unless he has a good knowledge of interpretation to advise the management. Unfortunately, we are weak in that. Let's admit that. And at least I admitted it once upon a time. Because we don't have sufficient knowledge developed during our curriculum, during our course. And you cannot compete with other professionals, particularly lawyers, solicitors, unless you have a sound knowledge of rules of interpretation of statutes. And for that purpose, in that view in mind, I have developed this booklet of about 150 pages. If you desire, you can definitely buy and keep it in on your desk or in your library. Now here, why may has been used is probably because my interpretation is that this provision has not been made mandatory in the sense that you must appoint shareholders, small shareholders directors in any case like a woman director. No. Appointment of a woman director is mandatory, appointment of independent directors is mandatory, appointment of managing or whole-time director is mandatory, appointment of key managerial person is mandatory, but not this. Because this will apply only when two conditions are satisfied. One, you get a requisition from so many number of people, and number two, actually at the meeting the resolution is passed as an ordinary resolution. When you say it is mandatory, it will mean that there is no need for resolution. You just appoint the person when you get a requisition from these many people. I don't think that is the intention. This provision is already there under the existing Companies Act also, I mean the 1956 Act also. It's not a new provision, only the criteria is new. Therefore, this is not a mandatory provision. Of course, and one more reason. They are also saying in one subsection that company can on its own, suo motu, appoint a small shareholders representative director. So if you wish to have a representative of small shareholders on your board, you can have it. You can appoint anybody as their representative. Of course, before doing that, think twice. Appointment of small shareholders directors is not mandatory, but it is subject to election. This director will have the same duties, responsibilities and liabilities. This director will not be different from other directors so far as duties and responsibilities are concerned. Appointment and retirement and reappointment. These are all requirements which company secretaries are concerned with. It is your responsibility to ensure compliance with all this. I would like to draw your attention to bullet number 2 and its meaning and effect. When you incorporate a company, the first directors would be named in the articles usually. Those directors will hold office only up to a general meeting, not annual general meeting, before the first annual general meeting. Which means that the first directors named in the articles will have to be appointed by the shareholders as directors in a general meeting, either extraordinary or annual, but before the first annual general meeting. So it cannot be annual general meeting. What you can do is, on the date of the first annual general meeting itself, prior to the annual general meeting, you hold one extraordinary general meeting and appoint them on the same day, at the same venue, but just before the AGM. So that will be technically appropriate compliance of this requirement. Then all these are procedural things, what to write in the explanatory statement. If they are independent directors, then what you should do. I think we should not default on compliances so far as disclosures and other requirements are concerned, because unnecessarily you will be caught unawares and you will also be held negligent about compliances. So we should not commit any default about it. Retirement of directors by rotation. As I said, section 255, 256. So in future, companies will have independent directors not liable to retirement. They will have executive directors not liable to retirement. And some companies may have nominee directors also not liable to retirement. But however, since you have to comply with this requirement of 152 section, 152 subsection 6, you must retire some directors every year if you are a public company. This is not applicable to private companies unless it is a subsidiary of a public company. Please remember, every private company which is a subsidiary of a company which is a public company. In simple words, every private company which is a subsidiary of a public company in India will be treated for all purposes a public company, except for the basic structure of the company by virtue of inclusion in the articles those conditions which constitute the company a private. This is a new provision, please remember. The definition of private company and public company now clarify that a private company which has become a subsidiary of a public company can retain its basic status as a private company, so far as those conditions are concerned, which we include in the articles. But for all other purposes, that company will be treated as a public company. This is one point. Another point, although not connected with this slide or this presentation, but I thought I should dwell upon that point, because I have seen several cases coming up. I have myself given about 3 legal opinions in the last 2 months on this subject. Whether a private limited company incorporated in India, which is a subsidiary of a foreign company, and the foreign company does not hold 100% share capital of the private company in India, whether that private company would be treated as a private company or a public company in future. This question has been raised at many places, obviously because the provision in subsection 7 of section 4 in the 1956 Act has been omitted, and that has created confusion. What is the status of such private companies? Because section 4(7) provided that if a private company is a subsidiary of a foreign company, which is a body corporate, which is not a company. Company incorporated outside India is not a company under the Indian Companies Act. Company has a distinct definition, separate definition. Only a company incorporated in this country is a company for all the purposes of the Companies Act. When the words used are body corporate, then body corporate includes foreign companies, not only companies incorporated in India, and therefore it is always said that every company incorporated in India is a body corporate, but every body corporate is not a company. Because bodies corporate which are incorporated outside India as companies, like for example, if you have a subsidiary or you have a company registered in UK under the UK Companies Act, That company is a company for the purposes of their Companies Act, but not Indian Companies Act. For Indian Companies Act, it is a body corporate. 4(7) section provided that if 100% of the paid-up capital of an Indian private company is held by one or more bodies corporate incorporated outside India, then that private company would be treated as a private company. It will continue to be a private company, which in other words means that if one or more bodies corporate outside India do not hold 100% of the capital of a private company in India, then private company would become a public company. It is a bit complicated, but it was there and it was practiced for the last so many years, right from 1956. Now that provision has been omitted. So if, for example, a private company in India is a subsidiary of a company incorporated in Japan, and that Japanese company does not hold 100% capital in the private company here, it holds say 99% or 98% or whatever, less than 100%, then whether this company in India, private company, would be private company or public company now, that question has acquired a serious proportion, and I do not understand why 4(7) has been omitted and without a new provision being created. This is a serious flaw. My interpretation is that all such private companies in which foreign companies hold share capital, whether 100% or not, would be private companies and not public companies. And therefore, they would not be subsidiaries of public companies and hence public companies. I think I am quite clear about this because this is an important issue with so many companies in India, mainly private companies, having foreign shareholding. There are so many examples, and therefore you will have to advise your management accordingly. Now, I do not know whether MCA is going to issue any clarification or not, because clarification is another problematic area. Many times in the name of clarification they confuse, like what they have done about 185, 186, etc. In any case, the Supreme Court has held in the Peerless case that circulars issued by the MCA has no legal status. They are not mandatory statutory provisions, they are only advisory and view of the government. I think they are also aware of this. Now, I have seen, yesterday evening only I have seen one document in which an interactive session with one registrar of companies was conducted by one of our chapters. I think it is in Karnataka. And that ROC expressed a view that according to him, of course that he took care to ensure that these are not MCA views, these are my personal views. But he correctly interpreted that, as I interpret it. And he said that all such companies would continue to be private companies and not public companies. So two things are important. One, the Indian company is a private company and it is a subsidiary of a foreign company, according to the definition of subsidiary. We have the definition of subsidiary, and you know, more than 50% of the capital holding or controlling the composition of the board of directors. Again, in that definition there is a problem, because they have removed the word equity, and only more than 50% of the capital should be held, which means preference share capital also should be included. They have made a rule saying that only convertible preference share shall be included. I said, why? How convertible preference shares become equity share capital before the date of conversion? They acquire the character of equity share capital, which is a voting capital, only on the conversion of those shares. But now they are saying in the rules that only equity share capital and convertible preference shares should be included. I do not agree with that at all. It is completely wrong, and my interpretation is that because in the definition of subsidiary, new definition, the word control is used, and if you go to the definition of control, which means only one thing, that is voting share capital. share capital carrying voting rights, which means only equity share capital. So preference share capital should not be included. Anyway, sorry for this deviation because I thought I should dwell upon this point also, which is creating trouble for many people. Now coming back to section 152, I think it's quite clear. There is nothing difficult now to practice it. I have explained everything. There is no other gray area now. You have to have at least 2/3 of the number of directors other than independent directors and nominee directors. As the directors liable to retirement by rotation, 1/3 of 2/3 should retire every year. But you can have all the directors also liable to retirement except independent directors. This is the framework of the law, and process of retirement and reappointment is not different at all from the previous law. It is the same, and there is a requirement of resolution to be placed at the meeting as an ordinary resolution. Then if a resolution is passed, that person will get reappointed. And I told you that in the case of managing and whole-time directors, if they are liable to retirement by rotation, then you will have to include one sentence that there is no break in their office as managing or whole-time directors. That is sufficient. Appointment of a new director at the AGM. I think this also we are very well conversant with. We had section 257, special notice with 500 rupees deposit. Now the deposit has been increased to 1 lakh rupees. And deposit will be forfeited if the person doesn't get 25% of the votes, or resolution is lost. So naturally, deposit will get forfeited. Otherwise, the requirement of notice is the same, like 257. The only difference is that 257 talked about both the notices, notice to be given by a member to the company, nomination notice, and notice to be given by the company to the shareholders. Now, half is in the statute, half is in the rules. Then, I don't think I need to discuss in detail. The only thing is that the person to be appointed as a director must have a DIN before the date of appointment. You cannot appoint a person unless he has a DIN at least on the date of the appointment. You can have only one DIN. Some people may have more than one. Additional director. Remember section 260. Board's power. In the provision about additional director, there is only one change, that a person who has been defeated in the election at the AGM cannot be appointed as an additional director. Alternate director, section 313, there is a lot of change, and I think all of us need to understand what that change is in connection with alternate director. So, when a director goes out of India, currently in section 313 it is the word state, goes out of the state within India. Now it is India. One person cannot be appointed as alternate for two or more. There are some cases where one person is appointed as alternate director for two directors. Alternate director's tenure will be the same as the original director. I don't think there is any difficulty about alternate director. Who can be appointed as alternate director? My answer is anybody can be appointed, whether that person is an Indian citizen or not. Even a non-resident can be appointed, but he should be in India. Because you appoint alternate director like a proxy for a person who is outside India. Nominee? 1956 Act does not have any provision about nominee directors. Those provisions are either in the articles or in the statutes governing a particular financial institution. For example, Section 6 of the Life Insurance Corporation of India Act contains a specific provision, like it was in UTI Act, it was in IFCI Act, it was in IDBI Act, and several other institutions, corporations of the government. And it specifically gives power to that corporation to nominate a director. Now, this has been made possible not only in the case of nominees of the government and government corporations or financial institutions, but also by private parties. So this change has to be understood properly. For example, in the case of a joint venture company, invariably the shareholders' agreement provides for nomination of persons as directors of the joint venture company by the partners to the joint venture, who are parties to the shareholders' agreement. That has also been now recognized. And these people can also be made non-retirable, subject to the compliance of 152(6), that every company must have at least 2/3 of directors liable to retirement. So these three provisions are quite important in my view for company secretaries: independent directors, nominee directors, and other directors, in connection with retirement by rotation and reappointment. Disqualifications. This is similar to section 274. A person who cannot be appointed as a director of any company in India. And there is a long list of disqualifications, and as I mentioned earlier, now company secretaries have to obtain declaration from the person proposed to be appointed as a director that that person is not disqualified for appointment as a director. And you will have to keep that in your records, because those companies to whom secretarial audit will be compulsory, the secretarial auditor will have to check this compliance. Now, so far as disqualifications are concerned, 2 or 3 points are important to note. One is that private company is free to provide in its articles any additional disqualifications, in addition to what this statutory provision provides. Then, second point is that 2 more grounds have been added in the list of old section 274. A person who has no DIN and a person who has been convicted of an offense dealing with related party transactions under section 188. Now the wording is problematic because offense dealing with related party offense dealing with related party is not the correct construction. What they want to say is that if a person is convicted of an offense under section 188 with regard to related party transactions, then that person will get disqualified. Now we will discuss 188 in detail, maybe after the tea break. That time we will touch upon this point again. But you have to remember one thing, that the words used are convicted of an offense. And in India, conviction is different from penalty in compounding or adjudication. Recently I have come across a case, a practicing company secretary giving a legal opinion to a company, and it's a real case, that if a director has been penalized by the CLB through compounding, because many of us must have gone through this compounding process, contravention of 297, this, that, and then we go for compounding. And sometimes they levy penalty on the company as well as directors. That is not conviction. That is not a conviction. Now this Companies Act has one more provision in addition to compounding, and that is adjudication. Like adjudication of certain contraventions under Income Tax Act or under Central Excise Law or Foreign Exchange Management Act, we are aware of this. There is adjudication. Even SEBI, there are many examples. SEBI adjudicating certain contraventions and levying penalties. That is not conviction. Compounding is not conviction. Adjudication is not conviction. Conviction is only that in which prosecution for contravention of a law goes through the process of a trial in the magistrate's court, and the magistrates give a judgment that the person is guilty and hence I convict him. And recently in the political aspect we have many examples of people being convicted by the courts, and that is only the court of magistrate, either regular magistrate court or special magistrates court, like CBI magistrate. But there should be conviction under the Criminal Procedure Code. This point is relevant not only for the purposes of this provision, but some other purposes also, particularly Part 1 of Schedule 5, which is equivalent to Part 1 of Schedule 13. Schedule 13 is now Schedule 5. And if you go through Part 1, similar to Schedule 13 Part 1, you will find that there is a list of laws, list of acts. And if a person is convicted and penalized up to a particular amount, I mean in excess of a particular amount, then that person cannot be appointed as a managing or whole-time director without the approval of the central government. I think all of you are aware of this. We have been doing it for years. That is conviction. I mean the requirement of that provision is conviction, not adjudication or compounding. Because sometimes, due to lack of knowledge of this aspect of criminal law, we tend to give wrong advice to our clients and then we find ourselves in trouble. 11:15, we have to break 40. 11:15, no? Okay. No, I have no problem. I think people will have a problem.
We can have 10 minutes question answer after it.
Before tea break? Okay.
I think it will take more time in the question answer. It will take at least half an hour.
Now we'll have one more round of seminar only for question answers. Yeah, that's what CCGRT is planning to do. CCGRT is planning to have program only on question answers. Yeah, because I have an anxiety to complete my presentation in the given time. and there are 136 slides. So I need to comply, and we are only on 25. And there are many important provisions in the latter part, that is chapter 13, remuneration and secretarial audit, and so that's why I'm trying to skip questions. Sorry for that. So we now deal with the disqualification which is similar to section 274(1)(g). I think all of us are conversant with that very well, because every year we take a declaration from directors, show it to the auditors, take it on record at the board meeting. All that process we have been following. Now there is some change in that provision. Basically, this provision will now apply in the case of private companies also. There was some confusion and controversy about applicability of 274(1)(g) in the case of private companies. Some interpretational problem. And ICAI was taking the view that they are applicable to private companies, but many people were of the view that they are not applicable to private companies. Anyway, now that is ended, because this provision will apply to private companies as well. And this is the provision. Financial statements means balance sheet, profit and loss account, and other statements required to be attached or annexed, which we used to call annual report. Now it is called financial statement. There is a definition given in section 2. There is a separate definition of financial statements, and everywhere now they are using the common phrase financial statements, which are required to be filed with the registrar within 30 days from the date of adoption at the annual general meeting. I think it's quite clear, and there should not be any doubt about its interpretation. Then there is a procedure laid down in Rule 14, which we'll have to follow. We'll have to take a declaration every year from directors that they are not disqualified in other companies where they have directorships, whether they are directors. And then now statutory auditor as well as secretarial auditor, both will have to check it. Number of directorships. In how many companies you can become director at a time in India? This is applicable to companies in India. Because the words used are company and companies. 20 maximum, out of which 10 public companies. Alternate directorship are to be included. Directorships in private companies are to be included. Because the explanation to subsection 1 very clearly says that for reckoning the limit of public companies in which a person can be appointed as a director, the directorship in private companies that are either holding or subsidiary companies or of a public company shall be included. When I was doing a secretarial audit of one listed company recently, I have seen a person holding directorships in 82 companies. And all of them except 2 were private limited companies. So that person will have to now step down in all the companies except 20. members can prescribe a lesser number. I don't think anybody will do this. Duties of directors. I think we'll complete this slide and break for tea. This is a sort of a code of conduct for directors. Not involved in a situation of conflict of interest and duty, but this is subject to the provisions of the Act which allow a director to enter into contracts or arrangements with the company, related party transactions. Unfortunately, this has not been clarified in this provision, but we have to read it along with other provisions which allow you to enter into, because for example, when a contract is being entered into by a company with a relative of a director, or a director himself or herself, it is a situation of conflict of interest and duty. Going by the general principles of fiduciary duties of directors, it is a case of conflict of interest and duty, but law allows it to do. The law allows it to do, and therefore this provision should be read along with those provisions, and when some provision allows you to do something, that should be excluded. Now, one point you need to note is, because some people are asking questions, why this section has been put into the Companies Act. It was not there at all ever since the beginning of company law in India. Neither in 1956 Act, nor in 1913 Act, nor in 1898 Act. Nowhere it was there. For the first time it is coming. And what is its relevance? Because this section, you will find, does not talk about penalty for contravention. It only says that a director of a company contravenes the provisions of this section, such director shall be punishable with fine up to so and so rupees. So it's only fine to be imposed. Then what is the purpose of this provision? In my view, this provision will enable the courts of law to invoke these duties of directors, like the regulations of the ICSI, which lay down a code of conduct for practicing company secretaries, and likewise ICAI or ICWI. And if there is a contravention of any of the provisions of the code of conduct, then disciplinary proceedings can be initiated against the person. And then whatever punishment institute can award can be awarded. Now these provisions can be invoked by the court of law when a matter relating to the breach of duty of a director or breach of any other provision comes before the court. For example, a Delhi High Court judgment given by Justice Sachar, who was the Justice of Delhi High Court, in Globe, the company's name is Globe, and the provision in question was relating to 297, 299 and 300 of the Companies Act. It's a very classic judgment given, very classic discussion about the duties of directors, fiduciary duties, etc. The company entered into a contract with a relative of a director, a firm, partnership firm, in which all the relatives of the directors were partners. The contract was for distribution of goods of the company. The contract was entirely one-sided so as to benefit the directors and his family at the cost of the company, which was a listed company, public company. Company complied with 297. If you remember 297 section, we are all conversant with that. The directors complied with section 299. the directors complied with section 300 and the company complied with 301. All these sections are in the same category. So all compliances were there. And the Delhi High Court gave a judgment that irrespective of the fact that all the provisions of the Act have been duly complied with, we will strike down this contract as null and void because it is so one-sided that the intention of the directors is only to extract money from the company, so as to give a benefit to particular people. And we will invoke, this is very important, we will invoke the principles of duties of directors by virtue of fiduciary position. Because directors are like trustees. We say that directors are like trustees, whether in reality it is so or not. As a principle, directors are to be treated as trustees, having fiduciary relationship. And the Delhi High Court struck down that agreement and asked the company to refund the entire money. Similar case occurred in UK. A consultant was appointed by the company for a takeover. The consultant was the director of the company. He had a consultancy firm. And £5 million were paid for consultancy of takeover. The Court of Appeal in UK asked the director to refund the entire money to the company because there was a breach of fiduciary duty in addition to the breach of section 299. There it is section 317. What I am trying to say is that these cases of course will be very rare and probably non-existent in India, but there is a possibility that courts will now invoke these duties, saying that you were under duty to do a particular thing or not to do a particular thing, and you did it, therefore you are liable, even if not penally liable, but for other consequences. So my only point is that we company secretary should make the directors aware of this. When you call the first board meeting now, hereafter, I suggest all company secretaries should place before the board a document mentioning the various requirements of the new Companies Act relating to the directors of the company, because they are not aware and they are not expected to know the company law. So you should make them aware, otherwise tomorrow they might say that you didn't tell us that this is the requirement. And this will be not only in relation to this, but also other requirements, like declarations to be given by them, various types of declarations, consents to be given by them, disqualification, related party transactions, loans, guarantees and securities not to be given by companies to certain parties, including directors, exemptions to that, in which cases loans can be given. All these things I think should be properly documented, or a presentation should be made to the board, maybe half an hour or so, and documents should be given to them, because otherwise these people will not be able to know all these nitty-gritty of the new Companies Act and might be unnecessarily exposed at some future point of time. So I think it is our duty to do this. And probably Institute can help us in this process. I think before we break for tea, we have about 10 minutes. So if there are questions on any of the issues discussed so far. But I suggest please speak on the mic so that others can also listen.
Morning, my name is Gehani. This tenure of independent directors of 5 years. I think there is a sentence in the consent clause that the tenure on the day of commencement of this act shall not be taken into account. Can you please spend 2 minutes for benefit of everybody?
Actually, this provision and the provision regarding auditor's appointment, both are relevant and both are in contrast to each other. Here, suppose you have an independent director who continued to be an independent director up to 1st April 2014, maybe for 10 years, 15 years, whatever. Anything beyond 5 years even, that tenure will be excluded. And there will be a fresh appointment for 5 years. In simple words, the prior period will be excluded in counting 5 years. So 5 years term, fresh term from 1st April 2014 or from the date of appointment, because 1 year's time has been given.
This 1 year can be taken for not appointing them.
Yes, yes, of course.
And then you can appoint them and then they continue for that. Means effectively it will be 6 years from today.
Precisely.
Commencement of the act.
Yeah, 6 years or even if he has been 10 years in your company,
Earlier.
then all those 10 years.
Earlier if they have been 8-10 years, that is gone,
Yeah.
plus the new provision of 6 years, 5 plus 1.
Any other question?
Sir, my question is on section 197, subsection 6, read with...
No, we are coming to 197.
Okay, because you dealt with that aspect during the
But
course of presentation.
can we have the discussion
Right,
afterward?
sir, another question basically is on, appointment of independent director. Can there be situations in a company wherein this name of independent director, who is very much qualifying the conditions laid down under section 149(6), read with
Six.
rules, can there be a situation when we have this nomination of this guy from the promoter? Suppose the promoter, is suggesting the name of a person to, say, an RC nomination remuneration committee, saying that this person should be appointed by you or recommended by you to the board for being appointed as an independent director, who is very much fulfilling the requirement criteria referred to in section 149 subsection 6.
Yes, of course. If the
The only
person,
concern which is coming to me is that nominee. Because in a way he is being nominated,
Who?
this new individual is being nominated, kind of, referred to the committee by the promoter. So can we link it with the concept that this person's name is being nominated or,
yes,
given
quite
to the...
possible. Yes. I don't see a problem because two things are there. Nominee director cannot be treated as independent director. Similarly, a person who complies with the parameters in subsection 6, who complies with all the parameters, can be appointed as an independent director. Now, if you do not formally say that he is a nominee director, because if you read subsection 6, first sentence, the beginning of section 149, subsection 6, an independent director in relation to a company means a director other than managing or whole-time director or nominee director. So other than executive directors and nominee directors, anybody else can be appointed as an independent director if that person fulfills the criteria in subsection 6. Now, if you do not formally appoint him as a nominee director under any agreement or under any kind of document or under the statute, any other statute like LIC Act, then he can be appointed as an independent. I do not know what are you contemplating when you say that the person is to be appointed as a nominee director by the promoters. Are you contemplating a situation that there is some document like articles or shareholders
No, sir,
agreement?
my only concern is from the perspective of nomination remuneration committee. Probably the moment his name is, nominated or referred to the committee, nomination remuneration committee, which is comprising a majority of independent director, may come with a reasoning saying why you are nominating a person. This is our job. Let us go find out a person of repute, skill, experience.
Don't do it in writing.
No, this is a kind of deliberation discussion which may take place between the promoter.
No, you have to advise the promoter. Don't do it in writing. No? Tell the chairman of the nomination committee that I want this person to be considered. Provided he satisfies the parameters. And he is not a nominee director in terms of any document. Any?
As on date, he is already an director under an agreement. And all directors are independent directors of nominee or shareholders, lenders. What is the situation
No, all directors are nominee directors.
of investor or lender. All are nominee directors appointed by the shareholder.
No, as I said, if there is any legal or legally enforceable document like shareholders agreement or articles of the company which gives power to a particular party to nominate a director, then there is a possibility that that person will be treated as a nominee director.
Yeah, as on
And
date-
then he will get excluded.
Yeah, because as on date, all 10 directors say. All
Then
are
you will,
nominee directors. That's
you will have to look for other people who are not nominees. Yes, yes, of course. Because nomination is usually under the articles or shareholders agreement.
Sir, one question from my side. There are many questions, but one question on this which you have done is,
One person is allowed only one question.
now, see, in the 1956 Act, Section 260 used to give the exclusion as regard the additional directors that 255 will not be applicable.
To whom?
As regard the calculation of directors' retirement. Now, what is happening in 161? That the exclusion provision has been removed.
Yeah.
The way I look at it is, while determining the total number of directors, no, you have to include even the additional director. When I am including the additional director, the total number of directors, which category I will file it,
Yeah.
fit it, whether it in the rotational director or in the non-rotational director, because that,
Yes.
so that is the basic issue, which is,
I agree with you. There is a problem about this because that exclusion has gone and that exclusion can be incorporated in the rules. It's quite possible. You put that exclusion in the rules, but then you will have to take up the matter with the
because
MCA.
reconstitution of the board, as many of they have raised, I am also ranting that
Yes, yes.
that becomes a very big issue at how to go.
The practical problem I concur with you, and the matter has to be taken up with MCA so as to amend the rules to include this.
So can I assume that the person who is retirement by rotation by virtue of this, irrespective of the fact that he is meeting all the criteria, but he is not an independent director?
Let me examine.
Yeah.
You wanted to ask something.
Hello?
Yes, he can be appointed in different companies. In the same company, one person cannot act as alternate director for two directors. No, I have no answer to government companies' problems because MCA has not yet issued any notification giving any exemptions to government companies, unlike under the 1956 Act. MCA, you have to ask MCA.
Independent
No, I mean, I'm not discounting your question, please don't misunderstand. But really there is no solution until MCA attends to this problem and issues notifications like under the 1950s. No need. No need.
The independent director,
In fact, it is possible that you appoint an independent director at a board meeting, take the resolution to the shareholders at the annual general meeting and make that appointment effective from the date of the board meeting. That is quite possible. Yeah, absolutely possible. Take the mic. You are not audible to me.
Good morning, sir. Thank you for the interactive section. Regarding independent director, we have a cooling period of 1 year. But in case we need to give the remuneration to our MD, so we need to go for remuneration, reconstitute our remuneration and nomination committee.
You are talking about independent directors or managing director?
No, I I'm talking about relating with the MD remuneration.
Okay.
So
But we have a presentation on
That
that.
is related to, sir, independent director. So there is one year cooling period is there, and
Oh, yeah.
so in nomination committee is you need.
No, in my view, if you take advantage of 1 year,
Yes,
which is statutorily available to you,
yes,
then that committee need not be constituted according to the new law
Yes.
for 1 year.
but sir, there
There is computer.
no cooling period is there in nomination committee.
I know, that is why I am saying,
Yes.
interpretation by harmonious construction rule
Okay.
is possible, that you don't implement that provision for 1 year and let the board take all decisions.
Thank you so much, sir.
I think, friends, we can break for tea. Okay, one last question. Please.
Yeah. So my name is Mahadevan. If there is an independent director who is running a law firm, who has been providing services, now in the new act, do you cover that particular law services, legal services as a pecuniary relationship and will not be
Yes.
considering as an independent director?
No.
Though he is not independently giving,
No,
but the law firm is giving.
he is holding an office or place of profit.
Okay. So he will not be eligible.
For example, if you enter into a retainership contract
Okay.
with a director who is tax expert or law expert
Okay.
or even a company secretary
Yeah.
or a chartered accountant
Yeah.
and pay him some special fees for retainer
Okay.
services, it is an office or place of profit and pecuniary relationship.
So if it is not retainership, if it is based on the project-wise,
Yes, still.
even then,
Yes.
suppose
Only the remuneration paid as directors.
Okay.
Okay, we break for tea.
Thank you.